Good afternoon, everyone. Our group is presenting on the Canada versus Australia measures affecting the importation of salmon, and I am Rujina Mallapati, talking about the background and facts of the disputes. This case is concerned a dispute between the Australia and Canada on Australia's quarantine restriction and measures used to prevent the importation of Canadian salmon in Australia. The parties submitted their dispute to dispute settlement bodies and WTO. There were significant global leaders in salmon exportation. They were Canada, Denmark, Sweden, New Zealand, and Australia during 1990s. Australia forced a restriction on importation of crispy salmon on an isolate guidelines. This dispute longed from 1975 to 2000. However, Australia allowed importation of salmon that were treated through a heat, can, or smoking for preservation. This helps to prevent the disease to spread in Australia. And Australia also argued that the Canadian new salmon importation posed a danger to mankind and other salmon in water. On the other hand, Canada misinterprets Australia's scientific evidence of the import risk analysis. It also argued regarding the disguised restriction of the international trade. And some facts of this case are inconsistent with the requirements with Article 5.1, 5.5, and 5.6. To maintain a sanitary measure is not based on risk assessment inconsistently with requirement of Article 5.1 of our agreement on application of sanitary and phytosanitary measures, and on ground acted inconsistently with the requirements of Article 2.2 of SPS agreement. And the second one is infringement of obligation by the Australia. According to the DSU, Article 3.8, the case consists infringement of obligations assumed under a covered agreement. The action is considered prima facie to constitute a case of nullification or impairment. Australia had nullified the Canada's benefits occurring under the agreement by acting inconsistently with the SPS agreement. Thank you.
Good afternoon, everyone. It's me, Osin, and I am going to continue my presentation about legal issues. First legal issue is risk assessment as per Article 5.1 and 2.2. The facts that demonstrated by the Australia had built up there was a hazard in bringing wild-caught salmon. However, the evaluation neglected to go inconvenient with the SPF agreement, and particularly the one contained in Article 5.1 and 5.2. And the second one is prohibition and discrimination of importation of product. The examination made by Australia wasn't concerned with the hazard. It's because there was no discernible connection between the evaluation and the prohibition of the salmon, and it is not consistency according to the Article 5.5 and 2.3. And the third one is a trade restriction on fresh salmon. The board was persuaded that the refusal of Australia and bans on solidified and chilled salmon required the merchants to warm the drums. And the last one is conduct new import risk analysis. The investigated body presumed that the Australia boycott was following distinguishing the infraction in additions to the organic and consecutive viewpoint. Thank you.
Hello, I am Asmita, EMP 80423, and I am here to continue the presentation on the topic individual parties and decision. The two parties involved in this case was Canada and Australia. Firstly, Canada. Canada sued Australia in 1994 due to the restriction imposed by Australia in importation of salmon. The country complained that Australia did not provide enough evidence to support their reason to impose the restriction. Canada argued that Australia's import ban violated the SPS agreement. Also, Canada complained that trade restricted imposed on Canadian salmon was overprotective, as impose was not on other aquatic products. Measures that Australia had taken against Canada were not on the basis of international standard. And the other party is Australia, which in defense argued that the complaining body, that is Canada, should present prima facie case in of inconsistency. Australia identified 24 disease agents of concern which were associated with importation of Canadian salmon. Australia set some product standardization that should be made in order to import the products like preserved and heated before exporting to Australia. Australia claimed that unless Canada could successfully demonstrate that Australia's measure did not conform of the provision of SPS agreement, measures would be assumed to be as per provision of GATT as per 1994 Article 2.4 of SPS agreement. Canada's argument did not go beyond an ascription of motive which was not relevant to the architecture and structure of the Article 5.5 obligation. Now the decisions that were made is to be discussed. On the request of Canada, WTO established the dispute settlement panel in April 1997 to resolve the conflict between Australia and Canada. The panel made Australia review its import guidelines, which they had to finish by July 1999. The case come into a mutual agreement between Canada and Australia to bring the dispute to close in 18th May of 2000, and these two came to an agreement in June 1, 2000, where Australia committed to implement all the aspects made in the agreement. Now, to continue the presentation, I would like to request my friend Khagi. Thank you.
Hi, good afternoon. Myself Kagipun. I'd like to continue upon the presentations. Now, I'd like to discuss about the importance of case in international law. Australia developed the new important guidelines where it informed industry that the Department of Agriculture and Water Resources is proposing changes that consolidate the important requirements for salmonid products sourced from approved countries. Australia currently has 3 types of approval for the import of salmonid product: 2 for uncooked salmon product and 1 for thermally treated salmon product. Held in similar case, that is US versus Canada. Like our case in US versus Canada case, there was ban to the dairy items and straight from creatures that are treated with hormones. Dispute panel focused on the protections of the health of human and animals. So there was a need to boycott imports of the wild grown up, especially salmon, because of diverse illness. European Union verified the ingredients for the new products, influenced the import of other aquatic products. And another thing is that the governing bodies should monitor the regulations often. The risk was analyzed by the evaluating each disease thoroughly, and alternatives were taken to prevent and cope with these hazards. Products that are consumer ready must wait with certification affirmed by AQIS, and if absence of these documentations, import will not be granted. Quarantine Act focuses on free market for Australia. According to Quarantine Act 1908 and Imported Food Control Act 1992, access to free market is critical to many of Australia's product export industries. Lastly, enforce the obligations through legal process. This case enforce obligations through a legal process which requires defaulting members to bring measures to conformity with obligations. Thank you.
Now, lastly, the conclusion. Canada complained against Australia regarding salmon imports, and as they don't have the sufficient evidence against Australia, they misinterpret the evidence of Australia. And finally, the dispute between 2 countries, Australia and Canada, came to an agreement, and procedure rely on the decision of the appellated body for the importation of salmon. Thank you.